friends, welcome to the To the Point. In this session, let's discuss about citizenship. Like any other modern state, India has also two kinds of people. One is the citizens of India and other is the aliens. The citizens are the full members of Indian state and they owe allegiance to it. They enjoy all the civil and political rights. And aliens, they are the citizens of some other state. And hence, they do not enjoy all the civil and political rights. And aliens are of two categories. One are friendly aliens and the other is the enemy aliens. The friendly aliens are the subject to the countries that have a cordial relationship with India. That is, they have a friendly relationship with India. Those people from that country, they are said to be a friendly aliens. On the other hand, the enemy aliens are the subject to that countries that is at war with India and they enjoy less rights than the friendly aliens. For example, they do not enjoy the protection against arrest and detention under Article 22. The Constitution, it provides certain rights and privileges on the citizens of India and it denies the same rights and privileges to grant them to the aliens. And those kinds of rights are rights against discrimination on the ground of religion, race, caste, sex or place of birth under Article 15 and right to equality of opportunity in the matter of public employment under Article 16 and right to freedom of speech and expression, assembly, association, movement, resident and profession under Article 19. Cultural and educational rights under Article 29 and 30. Right to vote in elections to the Lok Sabha and State Legislative Assembly and right to contest for the membership of the Parliament and the State Legislature. Eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of the States, Attorney General of India and the Advocate General of the States. And these are the rights given only to the citizens of India by our Constitution, whereas the aliens does not have all these rights. In India, both a citizen by birth as well as naturalized citizen, they are eligible for the office of president. Whereas in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Constitutional provisions. Our Constitution, it deals with citizenship from Article 5 to 11 under Part 2. The Constitution, it only identifies the person who became citizens of India at its commencement, that is on January 26, 1950. And it does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. So this article, it also deals with the empowerment of the Parliament to enact the laws to provide for such matters and any other matters that relates to citizenship. According to the Constitution, 4 categories of persons, they became the citizens of India at the time of its commencement. They are the persons domiciled in India. That means a person who had his domicile in India and also fulfilled any one of the 3 conditions. Like he should be born in India or either of his parents should be born in India or if has been ordinarily resident in India for at least 5 years before the commencement of the Constitution. Persons migrated from Pakistan. A person, one who has migrated to India from Pakistan also became an Indian citizen if he or she has any of his parents or grandparents was born in undivided India. In such a case also, a person should be registered as a resident in India for 6 months before his application for registration as a citizen of India. Person migrated to Pakistan but later returned. A person who has migrated to Pakistan from India after March 1st, 1947 but later returned to India for resettlement, they also became a citizen of India. Persons of Indian origin residing outside India. A person whose parents or grandparents was born in undivided India but who is ordinarily residing outside India, they shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence. It may be either before the commencement of the Constitution or after the commencement of the Constitution. Let's discuss about some of the other constitutional provisions with respect to citizenship. According to Article 9, no person shall be a citizen of India or he may be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. Under Article 10, every person who is or is deemed to be a citizen of India, they shall continue to be such citizen subject to the provisions of any law made by the Parliament. And under Article 11, the Parliament, it shall have the power to make any provisions with respect to acquisition and termination of the citizenship and all the other matters that relates to citizenship. Acquisition of citizenship. The Citizenship Act 1955, it provides for acquisition of loss of citizenship after the commencement of the Constitution, and this has been amended so far for 8 times. In the year 1957, 1960, 1985, 1986 and so on. The Citizenship Act of 1955, it prescribes some ways of acquiring citizenship. Let's discuss one by one. Citizenship by birth. A person, one who is born in India on or after 26th Jan 1950 but before July 1st 1987 is said to be a citizen of India by birth irrespective of nationality of his parents. A person born in India on or after July 1st 1987 is considered to be a citizen of India only if either of his parents is a citizen of India at the time of his birth. Citizenship by descent. A person born outside India on or after 26th Jan 1950 but before 10th December 1992 is said to be a citizen of India by descent if his father was a citizen of India at the time of his birth. A person born outside India after 10th December 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. And from 3rd December 2004, a person born outside India, he shall not be a citizen of India by descent, but he can become a citizen of India by the process of registration at the Indian consulate within 1 year of the date of birth of the person. Acquisition of citizenship by the process of registration. The central government may on an application register as a citizen of India any person if he belongs to the categories like a person of an Indian origin who is an ordinarily resident in India since from 7 years before making an application for registration, and also for the person of Indian origin who is ordinarily resident in any country or a place outside undivided India, and also to a person who is married to a citizen of India and he is ordinarily residing in India for up to 7 years before making any application for registration. Citizenship by naturalization. The central government may grant a certification of naturalization to any person if he possesses certain qualification like he is not a subject or a citizen of any country where citizens of India's or prevented from becoming their citizens of that country by naturalization. The person should either reside in India or be in the service of Government of India throughout the period of 12 months before applying for citizenship. Citizenship by incorporation of territory. If any new territory it becomes a part of Government of India, then the government specifies the person who among the people of the territory shall be a citizen of India, and such person they become a citizen of India from that notified date. For example, when Pondicherry became a part of India, Government of India issued the citizenship order in the year 1962 for Puducherry under the Citizenship Act 1955. Special provisions as to citizenship of persons covered by Assam Accord. The government will have a special focus on Clause 6. Clause 6 of the Assam Accord, it states that the central government will come up with constitutional, legislative and administrative measures to protect, preserve and promote the cultural, social and linguistic identity and heritage of the indigenous community of Assam. And every person of Indian origin who came to Assam from the Bangladesh and has been ordinarily a resident in Assam, they shall register for a citizenship, and such a registered person he shall become a citizen of India before a period of 10 years as he is detected as a foreigner. Laws of citizenship. The Citizenship Act 1955, it prescribes 3 ways of losing citizenship, whether acquired under the Act or prior to it under the Constitution. Loss of citizenship by renunciation, by termination and by deprivation. Renunciation of citizenship. Renunciation, it is an voluntary act of losing one's citizenship or nationality. It is quite opposite to acquisition of naturalization of citizenship. A person voluntarily acquires a citizenship and is distinct from denaturalization, where the loss of citizenship is forced by a state. Loss of citizenship by termination. When an Indian citizen he voluntarily acquires the citizenship of another country, then that person loses his citizenship automatically. And this provision, it does not apply during a war in which India is engaged. Loss of citizenship by deprivation. It is a compulsory termination of Indian citizenship by the central government or Government of India. If the citizen is said to have obtained the citizenship through the method of fraud and he has shown any disloyalty towards the Constitution of India, and if the citizen has unlawfully he traded or communicated with any of the enemy countries during a war, and if the citizen has been ordinarily resident out of India for almost 7 years continuously. Single citizenship. Though the Indian Constitution, it is federal and envisages a dual polity, that is center and state, it provides for only single citizenship, that is Indian citizenship. The citizens in India, they owe allegiance only to the Union, and there is no separate citizenship like state citizenship. The other federal states like USA and Switzerland, they have adopted a system of double citizenship. In USA, every person holds 2 citizenship. One is a citizenship of USA and other is a citizenship of their particular state to which they belong. Our constitution, like the Constitution of Canada, it has introduced a single citizenship and it provided uniform rights except in few cases for the people of India to promote the feeling of fraternity and unity among them, to build an integrated nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes also. Thus, the cherished goal of the founding fathers and our constitution makers to build an united and integrated Indian nation has not been fully realized. Overseas citizenship of India. Overseas citizenship of India, it is an immigration status permitting a foreign citizen of Indian origin to live and work in Republic of India. The Citizenship Amendment Act 2015, it has made some of the provisions to the overseas citizenship of India. Registration of overseas citizen of India card holder. Any person of the full age and capacity and who is a citizen of another country but he was a citizen of India, or any person who is a citizen of another country but he was eligible to become a citizen of India at the time of the commencement of the Constitution. A person who is a minor child and whose parents are citizen of India or any one of the parent is a citizen of India, or also a spouse of a foreign origin of a citizen of India, or a spouse of a foreign origin of an overseas citizen of India card holder and whose marriage has been registered and subsisted for continuous period of not less than 2 years can immediately proceed the presentation of application. Conferment of rights on overseas citizen of India card holder. An overseas citizen of India card holder shall be entitled to such a right as central government may specify in this behalf. An overseas citizen of India card holder will not be entitled to certain rights, like he is not entitled to have the right to equality of opportunity in public employment, and he will not be eligible for election as a president, and he is not eligible for election as a vice president, and he is also not eligible for appointment as a judge of Supreme Court or High Court. Renunciation of overseas citizen of India card. If any overseas citizen of India card holder makes prescribed manner a declaration renouncing the card registering him as an overseas citizen of India card holder, the declaration it shall be registered by the central government. And upon such a registration, the person shall cease to be a overseas citizen of India card holder. Cancellation of registration as overseas citizen of India card holder. The central government may cancel the registration of a person as an overseas citizen of India card holder if the central government is satisfied that the registration as an overseas citizen of India card holder, it was obtained by the means of fraud, false representation, or the concealment of any material or fact. And also the overseas citizen of India card holder will get cancelled if the card holder has shown disaffection towards the Constitution of India, or if the card holder during the war in which India is engaged, if that person unlawfully traded or communicated with the enemy country. In such case, the overseas citizenship of that person gets cancelled. See you in the next session with some other interesting topic. Thank you.